Oh, thank you. All right, after some technical difficulties, we're back. Welcome again to the First District Court of Appeals. We have one case for argument on Zoom today, and that is Aura versus LA Fitness, case number C-220211. For appellate, we have Mr. Aura arguing pro se, and for the appellee, LA Fitness, we have Mr. Kozar. If both of you, when you're not arguing, could please put your mute button on. So Mr. Ora, obviously you don't have to do that yet. Mr. Kozar, if you could please put your mute button on when you're not arguing so that we can hear opposing counsel without interruption.
Understood.
Okay. Mr. Ora, would you like to reserve any time for rebuttal?
I don't know how much I'm going.
Oh, I'm sorry.
So
you get 15 minutes to argue your case, and you can reserve as much of that 15 minutes as you want. You don't have to reserve any, but you do get the last word if you want to reserve some time for rebuttal.
yes, I do, but I don't know how long my initial argument will take.
Okay.
So
well, you only have 15 minutes. So
yes, I think that I will be just a few minutes. So the rest
you want 3 minutes or 5 minutes? Maybe?
Let's say 5 minutes. 5 minutes and 10 minutes to the end.
Okay.
Or something like that. Whatever.
I'll reserve 5 minutes. I'll let you know when you have a minute left of your initial 10. And then when you're done with your initial 10, I'll let you know. And then you can decide at that point if you want to reserve your 5. Okay. And Mr. Kozar, you are not muted. I need you to mute your computer because we're hearing stuff on your end. Thank you. Okay, Mr. Ora, whenever you're ready.
I'm kind of ready. I would like to ask the court. I submit my arguments of error, 3 arguments of errors, and I would like to ask the court if they read my brief, if there is anything that they don't understand that I can assist them in the argument of error number 1.
Well, why don't you go ahead and tell us why you don't believe that res judicata applies in your case?
Well, the first argument is the res judicata defense. Does not the defense used res judicata defense in his summary judgment in the trial court, and the defense cannot use res judicata defense because his answer to my complaint, which was 13 paragraph, he answered 13 paragraph, but without any affirmative defense, including the res judicata. And he was not filed a motion, so he didn't. So so in his motion, based on Rule 8C, there was no affirmative defense. He waived it, and that was October 4th at 9:54 in the morning that it was entered to the docket. And in his summary judgment that he filed at the trial court, he mentioned his answer, and he put it as exhibit. There is no any affirmative defense, no res judicata. In the trial court, in the hearing, I mentioned it twice to the trial court, and they both remained silent. So later that day, it was, so if you may recall, this case was in the past, and he always said res judicata did not exist. That's kind of strange, but nevertheless, now when he filed his, so I use several case law that says that the First District of Ohio does not let defendant use res judicata defense without mentioning it in without the rule 8C or by motion by rule 15. So he mentioned it for the in his summary judgment, which he's not allowed to. So he barred for use res judicata in a summary judgment. The trial court used summary judgment, this res judicata defense, and grant summary judgment to defendant, which, in my opinion, is improper. And according to the First District of Ohio, that's the case law that I mentioned.
Could I ask you though, on timing? So, after you filed the state case, you also filed a federal case based on the same facts, right?
Yes,
Okay. And at the time that the defendant filed their answer in the state case,
yes,
you're saying does not say res judicata as a defense.
yes.
Had the federal court yet ruled on your case that they're relying on? I mean, the federal court did grant summary judgment in their favor. Had they done that yet, but at the time that they filed their answer to your complaint in state court?
I'm sorry, I didn't follow the last part of your
Okay.
argument.
So at the time that you had two cases pending, one in state court and one in federal court, correct?
One case was pending, the state court, the state case.
But you also filed a federal case, right?
Yes,
Okay, at the same time.
yes,
And it was based on the same facts.
yes.
So at the time that the defendant answered your complaint in state court, had
And
the
then-
federal court resolved the federal case yet?
The case at the beginning was in the state court and federal court, and then the defendant filed a motion for stay, and then the state court grant a motion to stay, but his motion for answering to my complaint was prior, it was October 4th. Stay was November, somewhere in November. But he didn't answer to my complaint in the state court. His answer is defective. There was no certificate of service, and he filed it late, 9 days after, in the 39 days after I filed the complaint. So
Okay.
there was 3 issues here. He filed it late. He didn't file. There is no any res judicata is in summary judgment as exhibit. You will see it. And then he raised it for the first time in his summary judgment. He never talked about it, or what he says in the past prior to that, because this case was already in your court in the past. This is the second time. The first time it wasn't procedural, but then I raised this res judicata issue. All the time he said, res judicata doesn't exist. What that means? Yes, this to me, I'm not a lawyer, but it seems like it doesn't have any meaning. But nevertheless, it looks like that he was hiding behind a log, ambushing my case. So according to the First District of Ohio, I'm based on a case in the First District of Ohio. I conclude that he failed, and therefore res judicata should not be used in his summary judgment. In his summary judgment that he filed to Judge Higgins, which he ruled summary judgment based defendant res judicata defense.
So your argument is that he waived the defense.
Yes, he waived the defense, and I mentioned this in court in the hearing 2 times. Both of them, Judge Higgins and the defendant, remain silent. So but if he was, so, I was assuming because the defendant filed summary judgment based on res judicata defense, my motion after he filed summary judgment, I filed Rule 56F. But that motion was pending, and I thought that was pending because that was attached to his motion for summary judgment, the res judicata defense. But I wanted to mention this to him so he can rule on Rule 56F, so I can conduct discovery in his court, because I never conducted the discovery, and I had no opportunity, fair and full opportunity, to file to do discovery. So the ruling of Judge Hickens based on res judicata defense is improper. It should be denied.
And you're at 9 minutes, if you want to,
Okay.
10 minutes.
So,
Or-
do you have any, is the court has any question that I can explain? I use extensive case law to support my argument, including Judge Meyer. I think Meyer in 2015, it was a similar case like this. The defense filed, that was an issue after he did not file, didn't use his affirmative defense. He filed, he used it in summary judgment based on recollection, and it was not accepted because it was not in the request, it was not been accepted by the court. In other words, the defendant didn't file motion Rule 15 and request from the court to use res judicata defense in summary judgment.
All right, thank you, Mr. Ora. You are at your 10 minutes. If you'd
Okay,
like to reserve 5 minutes.
Okay,
Rebuttal.
so the
Okay.
second argument is based on the first argument.
Mr. Ora,
Yes,
you can, if you want to reserve 5 minutes, then you're gonna have to stop, and then we're gonna let Mr. Kozar speak.
okay, I
And
want
you'll
to.
get 5 minutes at the end.
Okay, may I continue for another 2.5 minutes?
You want another 2.5 minutes?
Yes.
Okay.
So I want to go to the third, because the second assignment of oral follow from the first from the first error. And which is so let me go to the third assignment of error, that let's assume that because of this, I don't think that the Court of Appeal would proceed on in ruling on summary judgment based on res judicata because of that issue. But let's assume that I'm wrong, and let go to the third assignment of error, that the trial court should not grant summary judgment based res judicata because it's not on the merit. And I provide in my brief several arguments why it's not on the merit. I had concrete evidence to show in my brief that the defendant was not speaking the truth. So, and it will be clear there is no any evidence, real evidence, legitimate evidence that support this conclusion. There is no any breach between the two. It's just up in the air. So there is, so that's what I have to say in a nutshell. But I lay down, among of them, the case was in the Ohio Civil Rights Commission. The Ohio Civil Rights Commission came up with a probable cause. This never took consideration by the district court and by Chicken. The administrative state court, a judge he can consider the administrative ruling of probable cause. Possible cause. I quote several cases from the 6th District of Ohio that it will be substantial weight to the decision of the administrative court from Ohio Civil Committee. There was a probable cause, but it's never been considered, along with other evidence to show. There was
Mr. Ora, you're at 13 minutes, just to let you
okay.
know.
So I'm done. Thank you.
Okay, all right. You have 2 minutes that you can reserve. Mr. Kozar, whenever you're ready.
Thank you, Your Honor. I respectfully rely upon and incorporate my briefs in opposition to Mr. Ora's appeal. My briefs explain in detail why his appeal is without merit. However, there are several points I do want to emphasize. The background: in July of 2013, some 10 years ago, the LA Fitness membership of Mr. Ora was terminated by Fitness for impermissible and inappropriate and aggressive behavior. Mr. Ora then filed 2 civil rights lawsuits arising out of that same incident, involving exactly the same parties, the same cause of action, and the same prayer for relief. One suit was filed in federal court and the other in the common pleas court for Hamilton County. And in its response to the state court complaint, defendant Fitness specifically pled the defense of the complaint being barred by res judicata in its special and affirmative defenses that I filed on October 4 of 2016. It's part of the record.
Counsel, that document was separate from the answer, wasn't it?
That's right.
Well, the answer was filed, they were filed within 24 hours. And the client filed the initial answer and sent the file case to me, and then it was the affirmative defenses were immediately filed within 24 hours. But that was raised. That specific affirmative defense was raised.
Without motion for leave.
Mr. Ora, could you please put your mute button on, please?
Oh, sorry.
The common pleas court then granted a stay of proceedings pending the outcome of the federal case. And after a substantial period of discovery, Fitness filed its motion for summary judgment based upon a lack of merit. And the federal court granted Fitness's motion for summary judgment for multiple reasons that specifically included a finding that Ora's membership had been revoked for several non-discriminatory legitimate reasons based upon the impermissible conduct.
Counsel, I want to go back to the separate notice of filing where the affirmative defense was raised. Is that separate document sufficient, or was the affirmative defense required to be contained in the answer? Can you address Mr. Ora's argument in that regard?
It was certainly raised, like I said, within 24 hours. So it's not a secret. It's not something that was not raised. As Mr. Ora is saying, nobody ever knew anything about it. And when the motions for summary, one for a dismissal in the common pleas court and one for summary judgment were raised, specifically on the grounds of res judicata, there was never any mention from Mr. Ora saying, no, it hadn't been raised. It was not, there was no objection to it whatsoever. So, and the court specifically found all of the elements that would be required for res judicata. The fact that the federal court had made a finding of no lack of merit based upon the facts, and it was a final determination on the facts, and that the parties were the same, the issues were the same, and the law was the same. Everything fit exactly within the parameters of res judicata. And then, because, like I said, Mr. Ora never raised that issue until his seventh brief or something in this appeal. There is the law, the specific law is that the applicable law set forth in my brief confirms that an issue raised for the first time on appeal is deemed waived. As such, his appeal should be denied, regardless of whether there was a 24-hour difference in the filing of the affirmative defense initially. And that's going back to 2016. So 6 years ago, that defense has been raised and has been a focus of the entire case once the federal court gave its ruling and dismissed the case on the merits. So again, if it's not raised until being on appeal, if there's any merit to that argument, then that argument is waived and the res judicata defense applies.
Just to understand timing wise, the federal court decided the case after you raised your affirmative defense in the state court, correct?
Yes, the federal court raised, the affirmative defense of res judicata was initially filed with the common pleas court, and then the common pleas court entered a stay of proceedings to see how the federal court was going to rule. And the federal court ruled that there was no merit to the case, dismissed the case. Then the case was rejuvenated at common pleas court, at which point in time we filed our first motion. It was a motion to dismiss, but it was based specifically on res judicata. No objection to that was raised by the judge, by Mr. Ora or anywhere else. That motion was granted, came to your court, and it was sent back for procedural error. And then the motion was refiled as a motion for summary judgment, again based solely upon the res judicata defense, where the federal court had addressed all the issues, had listened to all the evidence, had gone through the whole procedure with Mr. Ora and come to the conclusion that his case had no merit, filed its order of dismissal, and then we based our second motion for dismissal in the common pleas court for summary judgment, again based upon res judicata and based upon the fact that the same parties, same issues, same everything already been decided after extensive discovery by the federal court. And it was granted by the common pleas judge, who set it all out in his order of dismissal. And so, I mean, that's the position, Your Honor.
But just to be clear, at the time that you filed your affirmative defenses in state court, the federal court had not issued a ruling on the merits.
That's correct. No, that's correct.
So,
they had not.
So you would not have really been able to argue res judicata at that point because there had not been a ruling on the merits.
Absolutely, that's correct. I mean, it hadn't actually happened yet. There were no ruling from the federal court at that point in time, but it was raised because the parties were the same, the issues were the same, the incident was the same, everything was the same, and we obviously shouldn't be going through the same litigation twice for the same issues when it's already decided. When one court is deciding it, that happened to be the federal court.
Thank you. Do you have any further argument?
I don't think any further argument is necessary, Your Honor. I do appreciate your putting up with the fact that my video is not working. My apologies on that.
All right, well, unless my colleagues have any further questions.
Excuse
Okay.
me.
All right, thank you, Mr. Koza, for your argument. Mr. Ora, you have 2 minutes for rebuttal.
Okay.
Okay, I would like to emphasize the case was active at the time, at the beginning of 2016. The defense cannot use it's explicitly an answer to my complaint based rule 8C, missing all affirmative defense, including res judicata. Cannot play yes res judicata, not res judicata defense, both sides. The same day, he filed 19 paragraph answer to my complaint. Later on that day, with res judicata defense, 19 paragraph. My complaint is only 13 paragraph, but without motion for leave. It's two separate motions. This special thing, this is it pleading? What is it? So I don't think that his argument is valid here. He have to request at the time that he's working a motion for leave, and not just use it for the first time in a summary judgment. And I mentioned it to the hearing 2 times. The boss was silent. The judge and Mr. Kutzka. So his summary judgment, the ruling is invalid. And there is a case law. You will see there is several case law that I use step by step in very detail regarding this matter. With respect to that, using the definition of res judicata, that it's not on the merit, I have enough evidence, including the Ohio Civil Rights Commission of probable cause, that the six circuits point out that it should be substantial weight to the ruling of the Ohio Civil Rights Commission of probable cause. It's never took under account, and res judicata should not apply to the defendant. It should apply more to the plaintiff because of the probable cause. But so it's like upside down, it seems like. But there is many evidence that the defendant was not speaking the truth. Again, there is no any breach between the evidence and the conclusion. It's up in the air. It's some kind of a fiction.
Thank you, Mr. Ora. Thank you both for your arguments today. The case is now submitted, and we will issue a timely decision. So I appreciate you both appearing before us on Zoom today.
Thank you very much. I appreciate your help.